Hello, and welcome to Williams-Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm going to discuss some recent litigation that is a wake-up call for plan fiduciaries with respect to health and welfare benefits. Over the last several years, we've seen a wave of litigation in the area of 401k plans and 403b plans, where participants and plaintiffs are asserting that plan fiduciaries breached their ERISA fiduciary duty with respect to the selection of investment funds under a plan, or with respect to the funds or fees charged by service providers. And it's been since about 2018, multiple plans and plan fiduciaries have been sued, asserting these breaches of ERISA fiduciary duty. And this wave of litigation appears to have now hit the shores of health and welfare benefits. On February 5th, 2024, a proposed class action was filed against Johnson & Johnson and Johnson & Johnson's Pension and Benefits Committee. And the plaintiffs claim that Johnson & Johnson and their benefits committee breached ERISA fiduciary duties with respect to the selection of their group health plan's pharmacy benefit manager in agreeing to pharmacy benefit manager or PBM agreement terms that needlessly allowed the PBM to enrich itself at the expense of ERISA plan participants and the plan itself. They claim that the committee breached ERISA fiduciary duty with respect to the process of administering the plan's prescription drug benefits and in agreeing to unreasonable prices for prescription drugs. And an example in the complaint is that there was a particular prescription drug where you could go to Walgreens or CVS or Walmart and receive a 90-day supply from anywhere from around $22 to $77. The plan fiduciaries agreed to PBM terms where the plan was paying over $10,000 for the same 90-day prescription. The plaintiffs also assert that plan fiduciaries did not consider other PBM service providers and did not seek lower costs for prescription drug for the services of the PBM and did not monitor the services being provided by the PBM or its fees or the costs. And as a result, the plaintiffs claimed that participants were damaged by having to pay higher premiums for their group health plan prescription benefits, by having higher deductibles, copays, and insurance than otherwise would be reasonable, for having higher prescription drug costs, such as the $10,000 90-day supply of the drug that could cost as little as $22. And interestingly, also claimed that this resulted in lower wages for employees because so much money was being spent for the prescription drug and the prescription drug management program, and also resulted in limited wage growth. So we know that ERISA requires plan fiduciaries of retirement plans to exercise prudence in the selection of service providers and the selection of investment options under a plan. But there's really been a lot less focus on health and welfare benefits. But here the claims are pretty similar to the 401k litigation, where the plan's fiduciaries allegedly did not shop around the PBM services, did not try to find the lowest cost PBM, wasn't really paying attention to the compensation that the PBM was receiving through the plan, and didn't monitor the services being provided by the PBM or the costs. And so this lawsuit is really, as I said, a wake-up call for ERISA plan fiduciaries that you have to also pay attention in the health and welfare area, just as you do in the retirement plan area. So in thinking about what should a plan fiduciary do in light of this case, a lot of this, again, is similar to advice that we give with respect to retirement plans. There should be a benefits committee. There should be a group of people assigned to monitoring the performance of ERISA fiduciary duties with respect to not only the retirement plans, but also the health and welfare benefit plans. And these committees should meet on a regular basis. I think quarterly is a good frequency for meetings. And their deliberations and decisions should be documented in meeting minutes so that if challenged, a plan fiduciary could show that the issues were considered by the committee and that they made the best decisions they could under the circumstances with the information they had at the time. So once you have a committee, the committee should, if they're going to hire a pharmacy benefit manager for the group health plan, the committee needs to carefully review the PBM agreements and likely seek an expert's review of the agreement. I reviewed PBM agreements and they're voluminous and they kind of hide the ball. As in this Johnson & Johnson litigation, there are different ways that PBMs are compensated. One way that it's called spread compensation, and that's where a PBM will negotiate with the plan that the plan will pay $8, for example, for a prescription drug, and then the PBM will negotiate with pharmacies to pay $6 for the drug. And so when the plan pays $8, the PBM retains the spread of $2 as part of the PBM's compensation. A fiduciary who's looking out for the best interests of the plan and participants needs to be aware of this type of compensation and to determine whether it's reasonable. Similarly, PBMs receive compensation from pharmaceutical companies in the form of rebates. Plan fiduciaries should know the terms of those rebates and whether any of those rebates are shared with the plan and plan participants. Also, it's important to consider whether the formulary, the drugs listed by the PBM as covered under the plan, whether the decisions to include or exclude drugs from the plan's formulary is influenced by the rebates and compensation being received by the PBM. A plan fiduciary, the committee, once you have a committee, should do an analysis of this compensation, should demand transparency so that this type of compensation is disclosed to plan fiduciaries, and also monitor drug costs. Be aware that are we agreeing to pay $10,000 for a drug that should only cost $25? Be aware of those things and review the formulary to make sure that once you have an understanding of the types of compensation being received by the PBM, review the formulary to make sure that it is in the best interest of plan participants. And then, just as we recommend with respect to retirement plans that have record keepers and advisors, it's a good idea to have regular requests for proposals. Not necessarily that you're going to change the PBM, but at least see what services are provided by other PBMs and the costs of those services to just keep your current PBM honest, if nothing else, or to change PBMs if another PBM makes more sense for the plan. And then, as always, with any service provider, not just PBMs, monitor the performance of the service provider and the fees that are being charged. So once again, this is not that plan fiduciaries lacked anything to be concerned about or keep track of, but this is a wake-up call that in the health and welfare plan area, and especially with respect to pharmacy benefit managers, that plan fiduciaries have fiduciary responsibilities under ERISA with respect to fees and service providers in the context of group health and welfare benefit plans. So that'll wrap up my discussion of the Johnson & Johnson litigation. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.